Dean Erwin Chemerinsky in the 1980s, somewhere around 86 or so, in Southern California. He and I litigated cases together, and we became fast friends, and we've been friends in the decades since. We collaborate on a number of different things. He's one of the leading constitutional scholars. Where he finds time to do his work is beyond me. So you know who he is, you know his expertise, and I present to you Dean Erwin Chemerinsky. He's the dean of the law school at the University of California in or at Berkeley. Erwin, thank you for being with us, and I turn it over to you.
Thank you so much. Thank you for the kind words. What you didn't add, Ted, was when we met in 1980s in Los Angeles, we were both in middle school at the time. I'm deeply honored to have been asked to speak here today as part of this wonderful conference. I want to thank Ted and Jack Boger for this amazing invitation. I only wish we could be together in person. My thesis is that the Supreme Court has been a dismal failure in dealing with issues of race throughout American history. I fear that the foreseeable future, with 6 conservative justices, offers little basis believing that the court will be a force for racial justice. Indeed, I see a likelihood for the immediate future of just the opposite. We therefore must look elsewhere, but in doing so, I do find a basis for great hope for the future. I believe that other institutions can, and I'm cautiously optimistic, will act. The racial reckoning in the United States that began last May after the tragic death of George Floyd saw protests for racial justice in literally all 50 states. I am very hopeful that they will be the impetus for real change. It's understandable why we look to the Supreme Court to advance racial justice. We know that the political process so often has badly failed. We want the court to give meaning to the majestic language of the Declaration of Independence and to the constitutional guarantee of equal protection. We take heart, encouragement from when this occurred, most notably from cases like Brown versus Board of Education. We know to a certainty that elected Southern legislators and judges would not have ended segregation in 1954 or for a long time after. We watch today how legislators and elected officials are still systematically disenfranchising minority voters. We understandably want the judiciary to enforce the Constitution and move our society towards greater equality. This morning, beginning this wonderful conference, I want to address 3 questions. First, looking back and looking across time and issues, how is the court done with regard to racial justice? Second, what can we expect from the court in the foreseeable future? And third, and perhaps most important, if not the court, where can we go to pursue advances in racial justice? So let me start with the first of those questions. Looking back across time and across issues, the Supreme Court has a terrible record when it comes to racial justice. This is, of course, familiar to everyone, so I'll sketch all of this very quickly. But although it is familiar, I think it's important to look at this history together. Simply put, the sum here is much worse than the parts. Prior to the Civil War, not a single Supreme Court case chipped away at the institution of slavery or did anything to protect slaves. When the court was involved, it was entirely to protect slave owners and to uphold the institution of slavery. From 1787 into the adoption of the 13th Amendment in 1865, a period of 78 years, The court did nothing to further abolition. Everyone in this audience is familiar with Prague versus Pennsylvania in 1842, where the court enforced the Fugitive Slave Clause and declared unconstitutional a state law that prohibited removing an escaped slave, Pennsylvania, by force or violence. We celebrate Justice Joseph's story as one of the greats in Supreme Court history, but we cannot do that unless we overlook his tragically wrong decision in Prague versus Pennsylvania. Everyone here, of course, is familiar with Dred Scott versus Sanford in 1857, where the Supreme Court held that slaves are pieces of property, not citizens, even if they're born in the United States. The Supreme Court declared unconstitutional the Missouri Compromise as an impermissible taking of property of slaves from their owners. We should not excuse the court for these abhorrent decisions. The court could have and should have done much better in bringing about an end of slavery. From 1896 to 1954, the court articulated and enforced apartheid, the doctrine of separate but equal, which of course was separate and always unequal. The Supreme Court enforced the Jim Crow laws that segregated every aspect of life in southern states and many border states. Of course, everyone in this audience is familiar with Plessy versus Ferguson, the 1896 decision that upheld separate but equal. But we shouldn't forget the cases that followed it. Cumming versus Board of Education, 1899, where the Supreme Court held that the government could maintain a whites-only high school when no high school is available for blacks. Or Berea College versus Kentucky in 1908, where the court held that Kentucky could prohibit a private college from admitting blacks. Or Gong Lum versus Rice, where the court in 1927 held that Mississippi could exclude Chinese students from white schools. I could go on. So many other cases during this period of 58 years where the Supreme Court aggressively upheld Jim Crow. We look at the Warren Court as our model for advancing racial equality. But on reflection, I would suggest it's less admirable than it seems. Now, I don't want to deprecate the importance of the Warren Court's efforts. It did finally overrule Plessy. It did strike down the laws that created apartheid in every aspect of life. But there's also some other aspects of the Warren Court we shouldn't overlook. First, Brown itself was written narrowly, and it never explained why segregation was inconsistent with equal protection. Brown, in Chief Justice Warren's opinion, focused solely on how separate schools hurt the education of black children. What the court didn't explain was why segregation was inconsistent with the very essence of equal protection under the Constitution. So I'm sure you remember the Supreme Court struck down other laws imposing segregation without opinions. In a series of per curiam decisions, the Supreme Court declared unconstitutional the laws that segregated parks and beaches and playgrounds in every aspect of life. But never did the Supreme Court write the opinion explaining that equal protection inherently is meant to repudiate the idea of subordination of a race. Laws requiring segregation are based on that subordination. Second, even in the area of education, Brown did little to bring about equality or to end segregation. As everyone knows, when Brown was decided on May 17, 1954, it didn't indicate the remedies to be imposed to end segregation. The court had the case re-argued the next year. And then it didn't impose timetables, didn't prescribe remedies. Instead, what it said was that it would send the cases back to the lower courts to bring about desegregation with, quote, all deliberate speed. As I always tell my students, the very phrase all deliberate speed is an oxymoron. If you go back to the day after Brown 2 was decided and read the articles in the New York Times and other newspapers, the segregationists declared that it was a major victory. And it was, because the Supreme Court did nothing to bring about an immediate end to segregation. Justice John Paul Stevens, in a book many decades later, said that he believed that the court made a mistake in choosing unanimity over remedy. The result was that a decade after Brown, not one Black child was attending school with a white child in Alabama, Mississippi, or South Carolina. In North Carolina, where this conference is hosted, less than 0.1% of Blacks attended school with whites in 1964, a decade after Brown versus Board of Education. Third, we often forget that it was the Warren Court that was responsible for greatly expanding racialized policing in Terry versus Ohio in 1968. In Terry versus Ohio, the Supreme Court held that the police could stop individuals without needing probable cause, could search them without needing probable cause. The Supreme Court said that only, quote, reasonable suspicion was required. To this day, the Supreme Court has never defined what's enough for reasonable suspicion. As recently as 2020, the Supreme Court said it's more than a hunch, but less than probable cause. But study after study has shown how this standard of reasonable suspicion has fostered racialized policing. It has made it too easy for police to stop individuals solely for being Black or being brown. Statistics in every major jurisdiction, whether it's where I live in California or in North Carolina where this conference hosted, shows that Black and brown people are disproportionately stopped by the police, disproportionately frisked by the police. This was entirely foreseeable in 1968. The NAACP Legal Defense Fund wrote a stunning brief to the Supreme Court explaining how adopting a standard like reasonable suspicion would reinforce and even further racialized policing. Terry versus Ohio was an 8-1 decision. Only Justice William O. Douglas dissented. It came down from the most liberal Supreme Court we've ever had in American history. The majority opinion was written by Chief Justice Earl Ward. The majority included, among others, William Brennan and Thurgood Marshall. It's interesting to speculate why the Warren Court, at the height of its being liberal, handed down a decision like this. I think in part the Supreme Court was reacting to the intense criticism of its other decisions protecting criminal defendants in the 1960s. A case like Matt versus Ohio, Miranda versus Arizona. I think it has to be remembered that it was decided in 1968 in the midst of a year at a time when there were many urban disturbances. It's a time when there's great concern over crime control. But as we applaud the Warren Court for all that it did, we can't forget Terry versus Ohio and its tragic effects with regard to racial policing. The Burger Court that followed the Warren Court had a devastating effect on many key aspects of racial equality. Let me pick a couple of examples. In the area of public schools, the combination of San Antonio Board of Education, Rodriguez in 1973, and Milliken versus Bradley in 1974, created and institutionalized separate and unequal schools in virtually every metropolitan area in the United States. San Antonio Board of Education versus Rodriguez was a challenge to the Texas system of funding public schools largely through local property taxes. The result was that poor areas had a tax at a high rate of assessed valuation, but still had relatively little to spend on schools. Wealthy areas with large property tax bases could tax at a low rate of assessed valuation and had far more to spend on schools. Even in a single metropolitan area like San Antonio, with their different school districts, there was a huge disparity in funding for education. I grew up in Chicago. I went to Chicago public schools for a time. And the difference in the funding then and now between, say, the Chicago public schools and the New Trier and the Glenbrook public schools is dramatic. But the Supreme Court, in a 5-4 decision, upheld the Texas system for funding schools. Justice Lewis Powell for the court, he'd been appointed by Richard Nixon. His majority opinion was joined by Warren Burger, Harry Blackmun, and William Rehnquist, who had been appointed by Richard Nixon, and also by Potter Stewart, who had been appointed by President Eisenhower. Justice Powell, in his opinion, said that education is not a fundamental right under the Constitution. He said it's not explicitly mentioned, and it's not implicitly there. This, I think, is the most tragically wrong Supreme Court decisions in all of American history. The court also said that poverty is not a suspect classification. A year later, the court decided Milliken versus Bradley. It arose from the Detroit area, and it was an attempt of the federal court to desegregate the public schools there. Detroit, like cities throughout the country, was an inner city, city itself, that was predominantly minority students, surrounded by suburbs that were predominantly white students. Again, to focus on my hometown of Chicago, see the same thing with the Chicago public schools, overwhelmingly students of color, but surrounded by suburbs that are almost entirely white. The federal judge formulated a desegregation plan that would involve taking some of the students from the white suburbs and bringing them to the city, and take some of the city from moving them to the suburbs. The Supreme Court, again in a 5-4 decision, again with the 4 Nixon appointees in the majority, held that there generally cannot be such inter-district remedies. So you put these 2 cases together, you end up with city schools that have far less to spend on education and that are predominantly students of color, and the suburban school districts that are predominantly white that spend far more on education. These 2 cases did institutionalize the separate and unequal schools that continue to exist to this day. A second set of tragic decisions from the Burger Court concerned the requirement for proof of discriminatory intent. As everyone in this audience knows, in Washington versus Davis in 1976, the Supreme Court held that equal protection violations require proof that the government acted with the intent to discriminate. Case involved a Washington, D.C. requirement that in order to be police officers, individuals had to pass a test. Statistics showed that African Americans failed that test significantly more often than whites. But the Supreme Court, in an opinion by Justice Byron White, said that equal protection is meant to deal with purposeful discrimination. Discriminatory impact is not enough to prove race discrimination. In fact, discriminatory impact isn't enough to trigger more than rational basis review. It doesn't shift the burden of proof to the government to demonstrate that there is a non-racial justification for its actions. Discriminatory impact just means that the government is most always likely to prevail when there is a constitutional challenge. The court followed this up with other cases. In McCleskey versus Kemp, which was litigated by Jack Boger, the Supreme Court said that proof of racial discrimination in the application of the death penalty is not enough to bring an equal protection challenge. The court said unless it could be shown in Georgia, where the case arose, that the Georgia legislature adopted the death penalty for a discriminatory purpose, or that the particular jury had a discriminatory intent, there's no basis for bringing a challenge. In Mobile versus Bolden, the Supreme Court said that proof of a discriminatory impact with regard to an election scheme is not enough to show a violation of the 14th and 15th Amendment. The importance of these decisions in limiting the reach of equal protection cannot possibly be overstated. And then the Supreme Court followed them by making it very difficult to prove discriminatory intent. In Personnel Board versus Feeney, the Supreme Court said it's not enough to show that the government acted with knowledge that there'd be a discriminatory impact. It has to be proven that the government took the action with the desire to bring about the discriminatory impact. In Village of Arlington Heights versus Metropolitan Development Corporation, the court showed the very limited ways in which there can be evidence to prove discriminatory intent. These decisions so terribly narrowed the reach of equal protection and the ability of courts at any level of government to remedy the discrimination that exists. When we think of the Burger Court, in addition to these areas, we often want to focus on the one area where there seemed to be a triumph then for racial justice: affirmative action. In 1978, in Regents of the University of California versus Bakke, the Supreme Court, in a splintered 5-4 decision, upheld the ability of college universities to engage in affirmative action. Subsequent cases, like Grutter versus Bollinger and Fisher versus University of Texas Austin, have reaffirmed that holding from Bakke. But I would suggest that Bakke was less of a victory than it may seem. Bakke said that affirmative action is permissible only for the sake of enhancing diversity. The court rejected, and ever since has rejected, what affirmative action is really about: remedying the long history of discrimination, ensuring equal opportunity and equal playing field. When the court says that affirmative action is allowed only for the sake of diversity, isn't it really saying that affirmative action is allowed because it benefits white students who are able to learn in a diverse classroom? Doesn't the court then set up the criticism that later came from Justice Clarence Thomas, that it's really an aesthetic, that it makes us feel better to look out at a classroom with the diversity of faces that are there? I do not mean to lessen the importance of diversity. I've been a law professor for 41 years. I've taught courses like constitutional law and criminal procedure in classrooms almost all white, in classrooms with a significant number of students of color. The education for all students is better when there's diversity. But I think that the court made a mistake, a terrible mistake in Bakke, in rejecting what affirmative action is really about and focusing just on diversity. The Rehnquist and the Roberts courts have very much continued down the path begun by the Burger Court. In so many ways, the Rehnquist and the Roberts courts have set back the quest for racial justice. Let me mention just a few quickly. First, the Rehnquist and the Roberts courts have limited the ability of the government to deal with school segregation. For example, in Oklahoma City versus Dahl in 1991, the Supreme Court said that effective desegregation orders must end once they succeed. In other words, an effective desegregation order that really does bring about desegregation in the public schools has to cease as soon as that's achieved. The Supreme Court said that's so, even though ending the desegregation order will mean the resegregation of public schools. In Parents Involved in Community Schools, for Seattle School District number 1 in 2007, the Supreme Court said that public school boards for K through 12 cannot use race as a factor in assigning students to schools unless they meet strict scrutiny. Chief Justice Roberts wrote the opinion for the court. Famously, infamously ended by saying, The way to stop discriminating based on race is stop discriminating by race, and emphasized his view that the Constitution requires that the government be colorblind. The effect of these and other cases from the Rehnquist and Roberts courts have meant that our public school systems are ever more segregated. I remember speaking at a wonderful conference here at UNC Law School that Jack Boger put together about the resegregation of North Carolina public schools. The same thing has been seen throughout the country. A second effect of the Rehnquist and Roberts courts has been to further empower racialized policing. I have a book coming out this summer that's titled Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. And I focus a great deal on what the Rehnquist and the Roberts courts have done in this regard. Let me pick one example, and maybe it's less familiar to you than the other cases that I've been discussing. It's a case called Wren versus United States from 1996. It involved some undercover police officers who were driving around the District of Columbia. They saw a car that was stopped at a stop sign. So that was an unusually long period of time, about 40 seconds. I have the world's worst sense of direction. I am often stopped at stop signs that long. It used to be to try to read a map, now to look at my GPS. Solely on the basis of this, the officers decided to follow the car. They waited until the car turned without a turn signal. They pulled over the car. In DC, undercover police officers are not allowed to enforce traffic laws, but they pulled over the car for turning without a turn signal. They then, as they're allowed to do, ordered the driver and passengers out of the car. They did a search of the immediate area and they found drugs. No one denied that the traffic stop was entirely pretextual. But the Supreme Court unanimously ruled in favor of the police officers. Justice Scalia wrote the opinion for the court. He said, so long as the officers have reasonable suspicion for a stop, let alone probable cause, they're allowed to do so. Their subjective motivations don't matter. If any decision furthered racialized policing, the stopping of drivers just for being black or brown, it was Wren versus United States. It remains the law to this day. Final example, as I talk about the Rehnquist and the Roberts courts, is how it struck down crucial civil rights laws. We're all familiar with the Supreme Court's decision in Shelby County versus Holder from 2013. I think the Voting Rights Act of 1965 is one of the most important laws adopted in my lifetime. Section 2 prohibits state and local governments doing election systems that discriminate against minority voters. But Congress knew that wasn't enough. Congress had seen how especially southern states would repeatedly adopt discriminatory laws to disenfranchise minority voters. One would get struck down, only for another to be adopted. It was like the old arcade game of whack-a-mole. So Congress created Section 5 of the Voting Rights Act. Section 5 says that jurisdictions with a history of race discrimination in voting would need to get pre-clearance, pre-approval before significant changes in their election systems. Section 4 was the formula which provided for which systems, which election systems, which state and local governments would need to get pre-clearance. In 2006, Congress almost unanimously extended this for another 25 years. President George W. Bush signed it into law. By every account, this was enormously successful. But the Supreme Court, 5-4, declared Section 4 of the Voting Rights Act unconstitutional and thus nullified Section 5, the preclearance procedure. Why? What was the constitutional provision or principle that this violated? Chief Justice Roberts said it violated the principle of equal state sovereignty, that Congress must treat all states the same. But where in the Constitution is that found? I'm obviously not an originalist, but if there's any place where original meaning seems clear, it's that Congress in 1868, when it ratified the 14th Amendment, did not mean to require that all states be treated the same. The same Congress that ratified the 14th Amendment also voted to impose Reconstruction on Southern states, literally military rule over the former rebel states. And yet, the 5 most conservative justices in Shelby County v. Holder set aside their originalism and struck down this enormously important law. Very quickly, states like North Carolina and Texas instituted the very voting restrictions that preclearance had been denied for. So this is a very quick sketch of familiar history, but you can see when you put it together why I say the sum is worse than the parts, and the Supreme Court has a dismal history. It brings me to the second question that I posed. What now from the Supreme Court? Having painted a bleak picture of the past, I fear it's going to get worse with the 6 conservative justices on the current court. What might we expect in the foreseeable future? Let me suggest 3 things. One is a narrow interpretation of civil rights laws. I want to point your attention to a case from last term that didn't get much media attention, but is given effect with regard to many federal civil rights laws. It's a case called Comcast versus National Association of African-Owned Media. I should disclose here that I briefed and argued this case in the Supreme Court, and I lost by the close margin of 9-0. My client, Byron Allen, may be familiar to you. You might have seen him perform. He owns the Weather Channel. But that's not what this case is about. This case involves 7 cable channels that he owned. If you get DirecTV or Dish TV or Uverse, you would have these Byron Allen channels. But Comcast refused to carry them. Allen went and asked for them to be included in the Comcast service. The Comcast officials told him that there were many things he needed to do in order to be considered. He spent hundreds of thousands of dollars to jump through those hoops. He then went back and asked them to carry his channels. They said, sorry, they no longer had bandwidth. But he said, you've picked up in the meantime 85 white-owned channels. A Comcast official said to him, according to the complaint, quote, we don't want to create any more Bob Johnsons. Bob Johnson being the very successful head of the Black Entertainment Television Network. Allen, through the National Association of African Media, sued in federal district court in Los Angeles. The judge, in a short opinion, without explanation, granted Comcast's motion to dismiss for failure to state a claim. I argued the case in the Ninth Circuit in October of 2018, and I prevailed. The Ninth Circuit said that all that's required in order to sue under 42 United States Code, Section 1981, is to allege that race was a motivating factor in the denial of the contract. Section 1981 was adopted as part of the Civil Rights Act of 1866, the year after the Civil War. It says that all persons should have the same right to make and enter and enforce contracts as white citizens. And the Ninth Circuit said that Allen stated a claim for race discrimination in contracting. Comcast sought and received cert in the Supreme Court, and the Supreme Court, in an opinion by Justice Neil Gorsuch, said that in order to have a claim under Section 1981, it is alleged and proven that race was the but-for cause for the denial of the contract. Justice Gorsuch said that 1981 was written against a backdrop of tort law. Tort law requires but-for causation. I think historically, Justice Gorsuch is plain wrong here. There was an amicus brief filed in the court by John Witt of Yale and Mark Gergen of Berkeley that showed that but-for causation with regard to tort law didn't develop until the early 20th century. Why does this case matter? Well, as every civil rights lawyer knows, it's a lot harder to allege and prove but-for causation than show that race is a motivating factor. As an example, and the answer I gave to a question from Justice Sotomayor at oral argument is imagine somebody goes to a hotel to rent a room. And imagine that the proprietor says, sorry, we don't have rooms available. Besides, we don't rent to Black people. Imagine the complaint alleges those facts. If it's enough to say that race is a motivating factor, that complaint would stand a motion to dismiss. But if it has to allege that race is the but-for cause, that complaint fails. And what's particularly troubling about this decision is Justice Gorsuch, writing for a unanimous court, said that all federal civil rights laws are understood as requiring but-for causation unless Congress has specifically provided otherwise. Title VII specifically provides otherwise, but almost no other civil rights statute does that. So the Supreme Court here has very much narrowed the availability of civil rights remedies. I fear it's going to do so in other ways in the years ahead. I concluded my oral argument in the Supreme Court by saying Congress had such a broad remedial purpose for the Civil Rights Act of 1866. I said to the court, you have two different ways of reading the statute. One that every civil rights organization favors, as indicated by the amicus briefs filed. The other favored by Comcast and the Chamber of Commerce and the Trump administration, which seems more consistent with what Congress intended. 9-0, the court rejected that argument. Second, with regard to the foreseeable future, I fear that we're going to see an end of affirmative action. I ask you the following question. Are there 5 possible votes to reaffirm Bakke, Grutter, and Fisher? Remember, Chief Justice Roberts, in his opinion, and parents involved in School Statutes number 1, explicitly said that he believes that the Constitution requires the government to be colorblind. In Shuadi versus Bam, a number of years later, Chief Justice Roberts reiterated this view. I think there are now likely 6 votes on the Supreme Court, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, to say that Bakke, Grutter, and Fisher were wrongly decided. Obviously, I hope I am wrong. I believe that affirmative action is crucial to remedying past discrimination and achieving diversity. But I don't see any indication from any of these 5 justices in anything they've ever said or written that they would vote to uphold affirmative action programs. My hope is that the Supreme Court will not take the First Circuit case involving Harvard University, that the very factual nature of the district court and the First Circuit's holding mean that the court will stay away from it, and that the court will stay away from this issue for a number of years. But ultimately, I think so long as these 6 justices are there, it's not likely that affirmative action will survive. And to continue bleak predictions for the future, the third is, I'm very worried about what the Supreme Court's going to do with regard to statutes that allow for disparate impact liability. I mentioned earlier, and everyone here knows, that the Supreme Court has held that for equal protection, disparate impact is not sufficient. But statutes can allow for disparate impact liability. In 1971, in Griggs versus Duke Power, the Supreme Court held that disparate impact is sufficient under Title VII with regard to employment discrimination. The Supreme Court said that Congress, in the Voting Rights Act of 1982, effectively overruled Mobile versus Bolden by saying that for purposes of the Voting Rights Act, disparate impact is enough with regard to voting. In 2015, in Texas Department of Community Affairs versus Inclusive Community, the Supreme Court 5-4 held that disparate impact liability is allowed under the Fair Housing Act of 1968. As everyone knows, it is so much easier to prove disparate impact than it is to show a discriminatory intent. But I worry that the conservative justice on the court might go so far in the future as to say that disparate impact liability denies equal protection. Justice Scalia, in a concurring opinion, in Ritchie versus Stefano, outlined this. He said, disparate impact liability requires that decision makers take account of race in order to avoid liability. He said, for the government to require that decision makers take account of race is inconsistent with a constitution that he sees as requiring colorblindness. You find this echoed in some of the dissents of Justice Alito in voting cases, and most recently by Justice Thomas in his dissent in the Texas case in 2015. I worry that with this conservative majority, there could be a real threat to disparate impact liability under statutes. I, of course, so hope I am wrong in this fear. As we look to the foreseeable future, it's not just this year or next. Think about the age of the conservative justices. Amy Coney Barrett is 48 years old. If she remains on the Supreme Court until she's 87, the age at which Justice Ginsburg died, Justice Barrett will be on the court until the year 2059. Neil Gorsuch is only 53. Brett Kavanaugh is 55. Just a few weeks ago, John Roberts turned 66. Sam Alito will turn 71 on April 1st. Clarence Thomas is just 72 years old, even though he's been on the Supreme Court since 1991. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the Supreme Court. Justice Stevens didn't step down and retire until he was 90 years old. So it's possible to imagine that at least 5 of these 6 justices will be together for another decade or 2. So this then brings me to the third part of my remarks, the hopeful part. What are the alternative ways to achieve racial justice? I believe that there are other paths to achieve racial justice, not focusing on the Supreme Court or the federal judiciary. Let me outline 3 that I think are going to be quite important. The first is at the institutional level. What institutions can do so as to combat discrimination, to achieve diversity, to remedy discrimination. At the institutional level, I believe it will be possible to continue to engage in affirmative action, even if the Supreme Court overrules Bakke and Grutter and Fisher. And I can speak here from experience, having been part of the University of California system for the last 13 years. As I'm sure you know, in 1996, California voters adopted an initiative commonly referred to as Proposition 209 that ended affirmative action in the state. It said that state and local governments cannot discriminate or give preference on the basis of race or sex in education, contracting, or employment. Initially, this had a devastating effect on diversity at schools such as UCLA and Berkeley. The statistics are stunning in terms of the precipitous drop in Black and Latinx students. But over time, schools like UCLA and Berkeley have discovered ways to achieve diversity consistent with the end of affirmative action. I am at a law school where 50% of the students are students of color. In the time that I have been dean at Berkeley, we've gone from 12 African-American students in the first year class to then having 28 African-American students to 33 to this year having 43 African-American students in our 1L class. We've done this completely consistently with the decisions of the California Supreme Court and Proposition 209. UCLA, other UC schools have done this as well. California is not the only state where these initiatives prohibiting affirmative action. And Schools in these states as well found ways to achieve diversity. So the overruling of Bakke and Grutter and Fisher need not mean the end of diversity and the end of remedies for discrimination. My great fear is that overruling Bakke and Grutter and Fisher will have an immediate adverse consequence. It'll be like that scene in California. I worry also that it will let administrators who don't really care about diversity and remedying racial inequalities to throw up their hands and say there's nothing they can do. But at the institutional level, we must make a difference, no matter what the Supreme Court decides. Second, we must increasingly turn to state courts and state constitutions. In 1977, Justice William Brennan wrote an article in the Harvard Law Review urging the use of state courts and state constitutions. He had seen the change in the Supreme Court from the shift from the Warren to the Burger Court. He saw a conservative court for many years to come. He obviously couldn't foresee how long it would last or how conservative it would become. But he urges an alternative turning to state constitutions and state courts. We must do this, and we must do this in so many areas to achieve racial justice. And there are plenty of precedents where it's worked. Let me start with the example of marriage equality. The lawyers who are responsible for the strategy to create the right of marriage equality for gays and lesbians wisely began in state courts under state constitutions. They started, of course, in Massachusetts. And they didn't bring any federal claims. Had they done so, the case could be removed from state to federal court. They filed only claims under the Massachusetts Constitution. And in the Goodridge decision in 2003, the Massachusetts Supreme Judicial Court found that it violated the Massachusetts Constitution to keep gays and lesbians from marrying. There was then litigation in other states. It failed in New York. It succeeded in Iowa. It succeeded in California. There then were initiatives and momentum built. Had this gone to the Supreme Court in 2003, there is no possible way the Supreme Court would have found a right to marriage equality. But this strategy, beginning with state courts and state constitutions, meant that within a dozen years, 2015, in Oberfeld versus Hodges, the Supreme Court could find a federal constitutional right to marriage equality everywhere in the country. Or as another example, I point to how just a year ago, the Washington State Supreme Court found that the state death penalty violated the state constitution. The Washington Supreme Court's decision focused on the racial disparities with regard to the administration of the death penalty. The same kind of statistics that the court in McCleskey versus Kemp said didn't matter under equal protection were deemed to violate the Washington Constitution. Or the area of school finance. As I mentioned in San Antonio Board of Education versus Rodriguez, the court said disparities in school funding don't violate the United States Constitution. But many state courts, places like New Jersey, Texas, California, have found that disparities do violate the state constitution. Another example here is with regard to policing. Many state Supreme Courts have found that things that don't violate the United States Constitution, because Supreme Court's restrictive interpretations, the Fourth and Fifth Amendments, do violate the state constitutions. I gave the example earlier of Wren versus United States, which allows pretextual stops. Several state Supreme Courts have said that that's not allowed under state constitutions. I think some of the burden here is going to be on law schools. We need to do a better job of teaching state constitutional law. I think some of it is that the lawyers who litigate these cases that previously might have reflexively gone to federal court now need to think about using state courts and state constitutions. A third avenue for change is state and federal legislation. Congress, state legislators, local city councils can do so much to advance racial justice. Congress can adopt federal civil rights laws to fix bad decisions like that in Comcast. Congress can amend federal civil rights statutes to say that it's sufficient to show that race is a motivating factor. It doesn't have to be but for cause. Congress, for that matter, state legislators, can expand the ability to find violations based on disparate impact liability. At least unless and until the Supreme Court says it's not allowed, statutes can create disparate impact liability and need to do so. Congress needs to reform the voting and the political process, including adopting legislation to overcome Shelby County and reinstitute a form of preclearance. And Congress and state legislators can do so much to reform and change policing in the United States. They can outlaw practices like the use of the chokehold, racial profiling, no-knock warrants that lead to abuses and deaths. Congress, by statute, can change the standard of qualified immunity, which has provided protection for so many police officers who engage in excessive force, including that which leads to death. Congress can expand the liability for local governments to give them the incentive to oversee policing and make a change. As I said at the beginning, the protests for racial justice in every one of the 50 states provide an impetus for this reform. And it's our responsibility to continue that pressure. Though I paint a bleak picture with regard to the Supreme Court, I believe that there can be tremendous advances for racial justice through other avenues, such as the ones that I've mentioned. And I think if we look at these other avenues for change, we can have enormous hope and optimism for the future. Over the course of American history, there have been tremendous advances in our society with regard to equality and liberty. There is, of course, tremendous work to be done to solve the great racial inequities that remain in American society. But no one can deny that there's been progress. I was born in 1953, at a time when every southern state was segregated by law. Well, there's an enormous way to go with regard to progress in terms of sex equality, but there's certainly been great progress in all of our lives. Or I think with regard to sexual orientation, it is just 6 years ago that the Supreme Court held that state laws prohibiting same-sex marriage violate equal protection and deny due process. There's been a tremendous growth of freedom over the course of American history. I think that the late Dr. Martin Luther King got it exactly right when he said, "The arc of the moral universe is long, and it bends towards justice." Again, thank you so much for having me to begin this wonderful conference.
Thank you so much, Dean Chemerinsky, my dear friend Erwin. That was a panoramic tour of Supreme Court jurisprudence related to the 14th Amendment. And we want to get to questions and answers, although I want to cue up that we jump right into your address to get us started in a moment after we do question and answer. Alan Buenti, the Deputy Director of the Center for Civil Rights, will come to us with some housekeeping remarks. But I invite those of you who are able to and enabled to submit any questions and answers. We have a lot of people who are here virtually for the conference. We will only be able to take a few of them, but nonetheless, if anybody has questions and answers, or questions for answering rather, we'd appreciate your submission. A few questions just to start us off, Erwin. As I listened to your address, I was thinking about why this symposium at this time. I mean, you've been to many, many symposiums, participated in many of them, seen others. And here with this Supreme Court at this moment, why participate in another symposium on the 14th Amendment? If there had been a different and successful appointment by a different president after the passing of Justice Scalia, we'd be in a different moment, perhaps, or somewhat of a different moment. And certainly, if there had been an appointment by now President Biden after the passing of Justice Ginsburg, on top of that other possible appointment, we'd be in a different moment. And this would be a different symposium. Is this, I was thinking about the question about it, whether this is a sour grapes moment, or is there a productive purpose to our gathering virtually? Put differently, as the symposium is entitled, is there a way forward? And you seem to be indicating yes, but it's not 14th Amendment. It's not the federal Constitution. Yet, even though you said it's going to get worse, you come back to hope and the moral arc of the universe bending toward justice. And so I appreciate your hope, but in counterbalancing it with the sobering reality that you've talked about, the question is, how much can we really accomplish now? And whether what's left of the 14th Amendment that's constructive for people who want progressive change.
Let me answer the question this way. In November 2016, after Donald Trump was elected, the students at the school where I was, University of California, Irvine, were enormously upset. And they called a meeting of students and invited a few faculty to speak. And I concluded what I said to them by saying that we really only have two choices. We either have to give up or we have to fight harder. And that means we really only have one choice. We have to fight harder and better than we ever have before. I don't think we're going to succeed in most of those fights in this Supreme Court. It doesn't mean we're never going to win. In Bostock versus Clayton County, Georgia, just in June, the Supreme Court said that Title VII prohibits discrimination based on sexual orientation and gender identity. So that was a civil rights victory. But I think those victories are going to be few and far between in the court. I think what we need to do is to channel the energy into looking for other avenues for reform, which is what I was trying to talk about. But I also think one other thing, Ted, if we look to the long term, this court isn't going to be there forever. The court is an accident of history and the manipulation by Senator Mitch McConnell. There's going to be a time with a progressive majority on the Supreme Court, and we need to set forth now the intellectual framework for what it should be doing then. If only Merrick Garland had been confirmed, if only Hillary Clinton had won and replaced Kennedy and had replaced Ginsburg, we'd have that court today. But it's going to come, and conservatives did such a good job of laying an intellectual framework for the long-term future. So when they had control of the court, the agenda was in place. Progressives need to do that now, especially with regard to race.
Another question. Do you think the Supreme Court's resistance to the changes in the area of race are somehow special, more grudging than its holdings in areas of gender, sexual orientation, et cetera? And if so, why? Is it the reflection of the court's own prejudices or its silent assessment of the likely degree of popular and political resistance? To put it differently, it's significant that the marriage cases and the cases involving rights of LGBTQ people in recent years, they've come even when the court was conservative, maybe not as conservative as it appears to be now, but nonetheless conservative.
Yes, I mean, I think we have to focus on the fact that Shelby County was 5-4, and the marriage equality decisions were 5-4. United States v. Windsor in 2013, Oberfeld versus Hodges in 2015. In fact, if you think back to 2013, Shelby County came down on a Tuesday, and it was 5-4 with the 5 conservative justices in the majority, Ginsburg writing her stirring dissent, one of her very best, joined by Breyerson and Kagan. Literally the next day, the Supreme Court strikes down key provision of the Defense of Marriage Act, with the 4 liberals, Ginsburg, Breyerson, and Kagan, being joined by Justice Kennedy. Or the last affirmative action case, Fisher versus University of Texas in 2016. It's Kennedy who's joined by Ginsburg, Breyer, and Sotomayor, who's the majority in that case. So when we talk about the court, what we're really saying is Justice Kennedy was much more focused on and wanting to advance the rights of gays and lesbians, transgender individuals, than Justice Kennedy was focused on racial equality. And if you look at the current court, I think when it comes to marriage equality, it would have come out very differently today than it did in 2015. That said, I think the overall premise of the question is right, that the Supreme Court has been, over the course of American history, much worse with regard to race than with other kinds of discrimination.
That may be a piece of you. It's going to get worse. Your reference to the how these cases regarding the rights of LGBTQ people would have been decided if they were before the present court. One of our panelists who will speak later asked a variation of this question. Doesn't the likelihood that states and other branches of government presuppose a cultural desire to end racial discrimination, doesn't broad support for Trump suggest that such a consensus might not exist? Your thoughts?
One of the difficulties in relying on states, state courts, state constitutions is to win, you have to win in all 50 states, and that's not going to happen. Whereas if you can win in the Supreme Court, it's for the whole country. I think that there are places where there can be sufficient support for and substantial successful efforts towards racial justice. I don't think it's going to be in all 50 states. And you're right in the question that Donald Trump got 74 million votes, but Joe Biden got 81 million votes. And there are places like California where Biden won basically 2/3 of the vote. So in those places, I think that we need to use this impetus for racial justice. And hopefully that can then lead to pressure in other states where the political process is less inclined. But I'm not being Pollyannish. I'm not saying in all 50 states that there's going to be successful state legislation and use of state courts, but I do think it can happen in many places.
I want to ask a question or a combination of questions involving your case with respect to Byron Allen and Comcast, and connect it to something that we've seen in Fisher. There was a time many decades ago when the NAACP Legal Defense Fund almost had or virtually had a monopoly on race discrimination cases that went to the Supreme Court. That time is long gone. And cases come from all kinds of places now and involving all kinds of plaintiffs and parties. In your case, some people some people observed that Byron Allen may not have been the most sympathetic plaintiff because he was wealthy. And the connection with Fisher is the part of oral argument in Fisher where there was an exchange with Justice or between Justice Alito and a lawyer for the University of Texas when Justice Alito asked a hypothetical about, and you'll remember this, about Black parents who were a doctor, a lawyer. Why should they get the benefit of diversity? After all, he asked something like this, wasn't all of this about helping the disadvantaged? So the notion being that diversity really should not play to the benefit of wealthy or upper middle class people of color. Is there a hostility with respect to people bringing claims or being beneficiaries of diversity efforts? Those are two different things, but nonetheless, there's a connection here, arguably. Is there a hostility with respect to them and claims or diversity beneficiaries?
The obvious answer is yes. Now, what we've learned in California is that affirmative action solely on the basis of social class doesn't yield racial diversity. And the reason for that is simple arithmetic. Though a much larger percentage of African Americans and Latinx individuals are disadvantaged, in our society, the number of disadvantaged whites is greater. So if you create affirmative action solely on the basis of disadvantage, you don't achieve racial diversity, and you're not remedying the long history of racial inequality. But in terms of how judges react or justices react, of course you're right, Ted, that their instinct is Justice Alito said at the oral argument, well, why should this child of a Black doctor or professor be a beneficiary? It's a very narrow view of what affirmative action is about. And of course, you and I had conversations before the Comcast case was argued in the Supreme Court of exactly this issue. It wasn't, though, that Byron Allen took the case to the Supreme Court. Byron Allen won in the lower courts, and Comcast took the case to the Supreme Court. And there wasn't, we tried to find a path to keep this case away from the court and settle it, but there just wasn't such a path. And it ended up making very bad law. But the bottom line answer to your question is obviously yes.
Let me shift for a moment. Are you more hopeful when you think about the rights of Native American people, given the Oklahoma case, given McGirt? Do you have more hope with respect to a muscular application of the 14th Amendment?
I was more hopeful this past summer when McGirt came down. McGirt, for those who aren't familiar, involves a part of Oklahoma where there was a treaty between the United States government and the Creek tribe. And it provided that members of the Creek tribe who were prosecuted for crimes either to be prosecuted in tribal court or in federal court. And it allows individuals convicted in state court. And the Supreme Court, in an opinion by Justice Gorsuch, said that treaties have meaning and that the treaty between the United States and the Creek tribe had to be enforced. And this, especially the stirring language at the end about that, provided hope that maybe this is a court that's going to really advance Native American rights. But that was 5-4. Gorsuch was joined by Ginsburg, Breyer, Sotomayor, and Kagan. Roberts, Thomas, Alito, Kavanaugh dissent. Well, whether McGirt is going to matter much in the future is whether Amy Coney Barrett is more likely to agree with Gorsuch, Brierson, and Kagan, or is she more likely to agree with Roberts, Thomas, Alito, and Kavanaugh? My guess, everything we know about Amy Coney Barrett, is the latter is more likely than the former.
What strategies were used at Berkeley and UCLA after affirmative action was ended in California? What can other universities do more specifically? And I want to throw something else into that question, which has been submitted, and that's haven't you been conflating affirmative action with diversity? Is there anything to be gained by drawing a distinction between those two things?
Diversity is a goal. Affirmative action is a means. Now, diversity is a goal because of the educational benefits of diversity, but diversity is also a goal because it's how we remedy the long history of discrimination. Affirmative action is a means to achieving diversity. Obviously, there's many other means as well. If we would improve K through 12 education for Black and Latinx students, affirmative action would be less necessary at the college or law school level. But we can't wait for that to happen. I think that there's so much to say beyond our last minute or two about what the UC schools have done to achieve diversity in the face of Prop 209. And I hope, if ever my prediction would come true, and I hope it doesn't, that there's the end of affirmative action, that other college universities will look at places like the UC system or University of Michigan that are able to achieve diversity. I'll give one example, just an immediate one. As I said, my first year at Berkeley, which was 2017, there were only 12 Black students in the first year class. And I was enormously worried about that. I mean, I was horrified by the statistic, but also worried it would then create a self-fulfilling effect that fewer Black students would then come. And I asked my admissions team and a committee on equity and inclusion to look at what was it that, where were we hurting? Was it a lack of applications? Was it a lack of acceptance? Or was it a lack of retention, of getting them to come? And we learned that it was the latter, that there wasn't a lack of Black applicants or Black admissions, but they were choosing to go to other law schools. So we created a program of using our alumni, our students, and our faculty to aggressively reach out to those who we had accepted to try to recruit them. As I said, the next year jumped from 12 to 28, the next year to 33, this year to 43. And that's just one technique, and it proved effective. Now, I realize that what that means is we're not enlarging the pool. We're taking students who would have gone to other law schools. And what we have to do is enlarge the pool. And that's a whole nother conversation of the things that I think law schools need to be doing, college university doing, in terms of pipeline programs to enlarge the pool, not just take students from one school to another.
I want to go back to what you said, though, about institutions and diversity efforts / affirmative action, and ask what is a cheeky question, admittedly. Are you advocating another version of massive resistance if the Supreme Court strikes down, diversity efforts, affirmative action? What's different with respect to what you're saying about institutions and resistance in the 50s to Brown?
I think it's the difference in the goal, that the massive resistance of the 1950s was to perpetuate segregation. Here, if it's massive resistance, it's about remedying racial injustice. And to me, that makes all the difference. Now, what I'm urging with regard to massive resistance is that college universities find the ways to achieve diversity, even if they can't engage in affirmative action. And there are many ways of doing that, and I think they have to. And if it's to be called massive resistance, I'll accept the label, though the connotations of massive resistance are such that I think this is totally different because the ends are totally different.
It strikes me also that there's a question of a kind of formalism that would be at issue. If there are ways to pursue the goals that you and others, including me, of course, that we believe in, what what can be done that doesn't run afoul of what we presume, or I presume, would be a ban or a check on explicitly race conscious actions.
What I've always said as a dean, and I've been one for 13 years, to my director of admissions is, I care deeply about diversity. Just make sure that if I get sued, we have a good defense. And there are many things that can be done in the admissions process. Where Ted, you and I have been part of faculty hiring for a long time. What I always say to the appointments committee at the beginning of the year is, diversity really matters, but we should never articulate that we're favoring one candidate over another on account of race or sex. We can think it, we can vote it, but we should never say it and provide the record. We've hired 3 African-American professors in my short time at Berkeley, and as well as most of we hired at Bakke. We are not engaging in affirmative action, but certainly as we evaluate candidates, we can have diversity in our mind as something that's valued. But again, this is part of the longer conversation of how can college universities still achieve diversity, even if my prediction comes true and Bakke and Grutter and Fisher are overruled.
I want to thank you for spending time with us. Of course, for you, as I think I indicated, unlike most of the people who are with us virtually today, who will be speaking at least, I hope there are people on the West Coast who are also up early like you watching. But for you, it's very, very early in the morning. It doesn't in any way, diminish your, your sharpness, your acuity, and we're deeply grateful to you for spending your time with us, for challenging us, and frankly, for laying out some hard realities, but nonetheless, for also talking about hope, which I've come to understand and believe is not something that comes to us fortuitously, it's a choice. So thank you so much, Erwin.
Thank you for having me, and just such a wonderful conference, and I'm tremendously honored to get to be part of it.